with our Digital Law Center, which I have the privilege to run at our law school. When I prepared for the presentation, I must say that this was a bit daunting because, as we all know, and we'll get to see that in a few seconds, this is obviously a very dynamic area of the law and policy making in the already dynamic area of general AI-related policies. And we see that when we just look a bit of what's happening these days, just in a few days or so, to give a certain Geneva focus, as we all know, WIPO is intensively working on these issues. And interestingly, they have launched this series of conversation. The next one is coming up soon, as you will see on the screen. And that's also an interesting wording in the sense that the idea is certainly not at this stage to do some firm policy making, but rather to discuss, which shows somehow that there are obviously plenty of open issues, which also somehow sets the ground for my presentation today. And if we look around what's happening even the last days, we also have a very interesting document which has just been released by the US Copyright Office, as you can see on the screen, just published a few days ago, which, and if you go through that relatively extensive document, you will see there are plenty of issues for which the US Copyright Office is looking and waiting for input from stakeholders. So that might also be an opportunity for taking position for the SLTA to submit positions on these issues. And obviously, as we all know, beyond regulators, there are a few cases which are pending in jurisdiction, including the one that you have on the screen between Get Images and Stability AI, which was initiated in the spring, where basically the legal issue is to assess whether the fact of training this generative AI model, as you can read, can constitute a copyright infringement, showing that obviously there are still a lot of issues that needs to be decided, which somehow shows that obviously the ground is quite unstable from a legal perspective. So what I plan to do today is basically to offer a helicopter view, perhaps from Switzerland, but more broadly from a comparative law perspective, given that we all know that ideally we should aim for global solutions, even though, as we will see in a few minutes, there are still diverging views as to how that shall be regulated. Now, when we talk about input and outputs, we obviously have to be aware that this is an extremely broad topic. One topic that I will not touch upon, even though, of course, it's very important to practice, it's about personal data and the legality or not legality of data scraping. As such, you may have seen a joint statement which has been issued by various national and regional bodies in charge of personal data protection as to this issue. More generally, beyond copyright, and specifically with respect to patent law, this quite interesting and global, let's say, litigation scheme under the aegis of the Artificial Inventor Project, where there are cases pending almost all around the world on the issue whether AI can be qualified as an inventor under local patent law. And obviously, which is connected somehow next to copyrights, there are very challenging issues with respect to neighboring rights and personality rights, which are at stake and are being discussed, as we know, and as we've seen in the media in Hollywood, among other places, and which show that actors feel, of course, threatened by AI tools, which are issues which I will not touch upon further because they do not relate to copyright law as such. Now, one starting point, I think, before we do enter into discussion is just to look back, and sometimes it makes sense to look back a bit when we discuss about challenging issues, legal issues relating to upcoming technologies, is to think about the vision which somehow was at the core of copyright law, which is reflected on this famous picture that I'm sure most of you know from Karl Spitzweg, the poor poet writing poetry in his room, which insists on the individual but also artisanal way how works are created, which somehow calls for copyright protection. What does that mean if we translate that into legal terms and from a copyright perspective? That means that by essence and in a traditional manner, the copyright ecosystem is anthropocentric. Humans are really at the core of the system, which means, as you can see, that humans shall be the one owning initially the copyrights. They are the authors, which means also if we want to define what shall be protected, here again, we need human creativity. We'll of course get back to that later on. And also quite interestingly, if we look at what can constitute an infringement of copyright infringement, generally speaking, we consider that only an act which is perceptible by humans can amount to a copyright infringement. Now, and that's why I wanted to insist on that, this romantic vision is not fully reflected anymore. And you see a few examples, including the one that you're on the screen. First of all, you have cases, including in our own Swiss Copyright Code of Obligation, which basically grants the ownership of copyrights to non-authors, potentially to a corporate entity. You also have, quite recently, the introduction of the protection of non-original photography. So even if they are not creative enough, even if they don't reflect human creativity, these so-called photographic depictions, which are now protected under the Swiss Copyright Act. We may have quite probably a new protection of non-original short press releases by inspiration in order to kind of reflect what's happening also at the EU level. And you also have, in terms of infringement, cases of infringements which are realized or may be realized even if the activity as such is not perceptible by humans. And you have, without stopping too long on this provision of the Swiss Copyright Act, which is Article 24A, which creates an exception for this type of uses. Now, this being said, and this kind of shifts somehow the fact that copyright is actually not necessarily fully focused on humans, may still be relevant in order to see to what extent the copyright system should adapt, and if yes, how to the challenges raised by AI. So what I want to do, of course, in line with the title of the presentation, is basically to share a few thoughts and to look, of course, without claim of exhaustivity, certain selected issues dealing first with the inputs, and then, as you can see, with the output, whether that shall be protectable, and if yes, under what condition by copyright law, before a few closing remarks and takeaways, both at the macro level and the micro level, so company level, so to say, corporate level. So in terms of inputs, I don't think I have to spend much time on that page, given that we all know that obviously the value of AI tools depends on the processing and collecting of massive amount of data of different sorts, be they images, sounds, and so on and so forth, and then to use this to train a model from a copyright perspective. Obviously, that may raise issue and may constitute an infringement. Interestingly, reflecting to what I was mentioning earlier, even though this might not be perceptible by humans, so these are kind of an internal processing mechanism, but for which some exceptions to copyright law have been implemented at the local level. You have on the screen the provision that has been recently adopted in Switzerland. As you will see, and this is already contained in its very title, this is limited to scientific research, meaning that a commercial use is not covered by this, even though in the legal literature you may hear and see voices pleading for more extensive application of that exception, which would make it possible to basically process, to do some data mining and text and data mining, the TDM exception that you have reflecting on the screen. Now, what's happening abroad? Obviously, I'm not going to go on a world tour, but just look at what's happening in Europe and then move to Asia and look at what's happening in Japan, because as we'll see in a second, they have adopted a quite innovative regulation, quite AI-friendly regulation, as we'll see. With respect to Europe, and I will not read aloud what you have on the screen, there is, first of all, this provision of Article 3, which here again, as you will have noted, is limited to scientific research, or is a relatively narrow field of and scope covered by this exception. You have, perhaps more importantly, from a business perspective, an exception which is anchored in Article 4 of that Directive 2019-790 of April 17th, 2019. You have a broader exception which may apply also in a non-scientific setting, with the possibility, which is quite important, which is at the bottom of the screen, which makes it possible for the IP owner, for the copyright owner, to opt out, to reserve the rights, which would then mean that this exception would not be applicable. So there is a possibility, of course, depending on how this is implemented locally by the member states, but there's this possibility of opting out. Now, what about Japan? And interestingly, you have here again this same issue appearing, meaning that you may infringe copyright even if, as you can see, and I'm not sure about, of course, the quality of the translation from Japanese, but if you look at the title of that provision, exploitation without the purpose of enjoying the thoughts or sentiments expressed in a work, meaning that can be infringement even without perception by humans. And they have created this quite broad exception, as reflected on the screen, which, if you look at the three bottom lines that are reflected on the screen, basically are here to confirm that this exception should still be compatible with international copyright law, meaning that we don't want the AI tools to be limited by copyright infringement risk. And that is supposed to apply for data analysis. And this is basically what we're talking about in the way which is formulated on the screen, the extraction, comparison, classification, and so on and so forth, irrespective, as you can see, of the type of content, basically language, sounds, image, and other type, and insisting, as you see at the bottom of this provision, on the volume, on the massive volume which is at stake, which is exactly what we're talking about when talking about the need to feed an AI tool. So what can we say and try to derive from this? And you have here an interesting policy paper which was elaborated at the Max Planck Institute, which is, of course, a leading think tank with respect to IP in general. And they have issued that report relatively recently, where they say, in essence, as you can read, there is a need somehow to perhaps make the exceptions a bit broader, the ones that are reflected at the EU level at least, in order to make to facilitate the development of AI system. One issue, which is perhaps a side issue, but I will still briefly mention, is the issue as to whether the fact of training AI tools by using copyrighted work may also violate the moral rights. As some of you will know, moral rights are the types of rights which are anchored in copyright laws, which are deemed to protect the non-economic aspects, so-called moral rights of the authors, and specifically the right of integrity, meaning that the work shall not be used in a manner which would be distorting that work. And this is the claim here, that the fact of using works in AI tools might be detrimental to moral rights. To be frank, as far as I'm concerned, I don't necessarily think that will be the case. Also, for the reason that I was mentioning earlier in the introduction, because in that case, this alleged violation would not be perceptible by humans, would be purely internal process. When we talk about this issue, of course, one question which may arise, and of course of particular relevance if we look at the international IP system and the international copyright system, specifically the one resulting from these Geneva-based international organization, World IP Organization, but also the World Trade Organization and the TRIPS agreement, is to wonder whether that is compatible creating TDM rules, text and data mining exceptions, or are they compatible with international law? You have diverging position, one which is reflected on the screen by a leading scholar who, as you can read and guess from the title of the article, basically claims this is a non-issue, meaning that the member states of the countries, including Switzerland, perhaps may want to expand and grant more broader exceptions for the purpose of facilitating data processing in order to feed AI tools. And one last interesting development that has to be mentioned when we talk about input is about what results from the latest version of the, of course, famous and extremely important AI Act, which I'm sure is also on your respective radar, which provide, and this is the relevant provision on the screen, for an obligation of transparency. And this is obviously, and we get to see that again in a few minutes when we'll be moving to output. This is something which perhaps is the most important obligation, which may result at this stage, at least, when we talk about AI and copyright, to try and see how we can create new obligation of transparency. In this case, in order to disclose, as you can read, what types of documents or works have been used in order to train the data in this AI tool based on that provision of Article 28B of the EU AI Act. Now, if we move to output, even though, of course, we could debate, and that would certainly be the case if we go back briefly to this ongoing consultation done by the US Copyright Office. As you will see, if you look at the document at the end, they have come up with a set of definitions, and they have also expressly asked the commentators to make comments, if need be, on the definitions. What I'm saying here is that we may have certain definitions, but it may well be that these definitions do not hold or maybe be challenged in the future. So what we have here on this result from what WIPO has been doing, and you have the reference on the screen, is to distinguish between AI-generated output. So, and you see that the line of distinction is as to whether there is or not human intervention, and AI-assisted output. And in case, of course, as we will see in a second, and I'm sure many of you already know, if there is no human output, and based on what we could discuss earlier, there's no human intervention, the position which has been defended so far, including in the US, in this case that you have on the screen, there was a very recent decision to which we'll get in a few slides. The position was basically to say there shall be no protection because there is no humans behind the creation process. And this is basically what the US Copyright Office decided in that decision that you have on the screen. And this was confirmed quite recently, as you see, in that dispute between the same person, Tyler, who was actually also the one involved in this AI artificial inventor project. In this case, pending before the district court for the District of Columbia, as you can see, in which basically this requirement of human authorship is really considered as a, as you can read, bedrock requirements of copyright law. Now, of course, the next question is, the understanding is, at least as of today, is that we need some human creativity. So what shall constitute human? Is it sufficient to do some kind of prompt engineering to be sufficiently humanly creative, so to say? You have also an ongoing discussion. You have, for those of you who are interested, a very recent paper which has just been published in this leading IP law journal, which basically discusses this as to whether you can qualify as an author simply by kind of using an AI tool to generate new output. There might be diverging views. In this case, another case coming from the US, dealing with work that you have on the screen, where in essence, the position was that the input, which was made by the human, Mrs. Casanova, as you can read, was not sufficient. Why is that? Because you have the answer on the second line here on the screen. Midjourney, if I quote, generates images in an unpredictable way. So the input was not sufficient to trigger and to make it possible to qualify for copyright protection. We also see that if we come briefly to Switzerland, this reflected in the so-called principle of the creator, Schöpferprinzip, that is reflected also and confirmed without challenge, at least as of today, in the case law of the Swiss Federal Supreme Court, including in the decision that you have on the screen, with the exception, as you can see, of this provision that I briefly mentioned earlier in the introduction, 393, paragraph 2 of the Swiss Code of Obligation, which precisely constitutes an exception and makes it possible, for instance, for a company to own copyright initially. Now, next question obviously is to wonder what would happen if someone would claim falsely that he or she would be the author of an AI-generated content. Why would that person do that? Obviously, because that might perhaps create the impression that this work has been created by human, and of course, that would lead, at least as of today, to the grant of copyright protection to that content, even though that content would have been created by an AI tool. You have a provision in the Copyright Act, which is also anchored at the international level, which creates this presumption of authorship, saying that if you put your name on the work, that creates the presumption, basically, that you are the author and potentially that you would deserve the protection of copyright. Now, the question, how do you prove this? And this is where we go back to this principle that I had mentioned earlier. Earlier, we had discussed about this from an input perspective. Now we talk about it from an output perspective, is transparency. And this challenge was identified in that report, AI Music Output, which is available online, where basically they say this is a problem because potentially this may put somehow under the protection of copyright law of some content which should not deserve that protection because it has been generated purely by an AI tool. And we get back to this principle of transparency, by which the idea would basically to say we should create this, as you reflect on the screen, these additional transparency measures, which shall make it possible somehow to identify what would come from a human and what would not come from a human, meaning that what doesn't come from a human shall not be protected by copyright. Can technology help? Sure, technology can help, and you have different projects. If you go online, you'll see many initiatives and projects, including the one which has been launched at Stanford University. You also have tech companies which do offer this type of tools, including the Adobe system, which promotes, as you can read, transparency in AI under the aegis of this content authenticity initiative. You also have this for images, and I, of course, could not resist taking these images, which is available on the screen, where, as you may hopefully see, the left side of the wonderful picture with the Matterhorn in the background and the cow in the foreground is watermarked, and the right side is supposed to be non-watermarked, and indeed, we don't see much of a difference in this respect. Interestingly, you also the markets beyond the technological solutions, which somehow moves in that direction of transparency, including in the advertising industry, where this so-called AI Accountability Act, which is actually not a regulation, but more kind of a soft law approach, which has been launched on the market quite recently, which is supposed to materialize in what you have on the screen, this kind of hashtag powered by AI, which would then identify the type of content which would have been generated by AI, which, of course, from our perspective here, would then not deserve copyright protection. Now, how can we look at it from a legal perspective? Could we somehow create an obligation of transparency one potential approach would be to look at the general, let's say, not IP focus, but general AI regulatory framework. And you have what is somehow emerging from various documents, as we see on the screen, or we see on the next page, some kind of a growth in an emergence of this so-called digital right to algorithmic AI transparency, which of course is not focusing on IP and even less on copyright law, where basically users who are kind of in contact and interacting with AI tools should know that some AI tools have been used and be informed about that. You see that in this so-called European Declaration on Digital Rights and Principles for the Digital Decade, so kind of a constitutional rights or fundamental rights in the digital age. You also see that emerging in various AI kind of soft law instruments, including the one that you have on the screen, OECD AI Principle, where you also have, as you can see, a kind of similar transparency and explainability requirement. So that may mean that we could experience in the future the development of these digital rights, which would basically be justified by the need for the public and also for potential user not to be misled about the false existence of claimed existence of copyright protection. Of course, it's of critical importance to know whether the content is protected or not, and to make sure that this might materialize in an obligation, active obligation to disclose the non-human source of AI-generated content. So we may see at some point in the future some kind of convergence between a general algorithmic transparency which exists, which we have just seen in this document declaration from the EU, to perhaps more focused copyright transparency, knowing that, and this is what you have on the screen, transparency seems to be emerging more and more as a growing value, so to say, in the copyright system. Transparency obligation in that directive, Article 19, you see that value somehow in this right and obligation, depending on the stakeholder, to look at that quite carefully and to make sure that this can also be implemented for potentially disclosing the non-human nature of certain content. Now, obviously, the question is, what if someone claims falsely that he or she would be the author of a given work whereby this would have been created purely by an AI tool? You may think to expand somehow some existing legal tools, including the DRM. So what if you have a work or a watermarking system which is associated to a digital content, and this watermarking would be amended in a false manner in order to claim an identifier author who would indeed not have been the one who have created. That might be perhaps a development that we could see in the future in order to fight against these false claims of authorship. Another potential avenue would be to perhaps get inspiration from this concept of Patentberührung to some kind of a copyright-related adaptation, which basically relates to the activity, and this is taken from the Swiss Patent Act. As you can see, this is the title, translated title of Article 82 of the Swiss Patent Act, which prevents, again, the activity of false patent marking, where you basically claim that something would be, a product would be benefiting from patent protection, whereby that would not be the case. Perhaps we may use that as a reference, as a potential source of inspiration, and apply that in the copyright setting. Which brings me very briefly to takeaways. As I was mentioning in the introduction, we could look at that, I guess, in two ways, perhaps starting from the ground and perhaps moving up to a more macro level in terms of geopolitics of AI. The first level is trying to see what can be done potentially by companies in order to mitigate, at least, or perhaps control even better, the copyright-related AI risk. Obviously, my ambition is certainly to talk about managing AI risk in general, but to focus on the copyright-related AI risk. And why would we have to do that? Obviously, because we know, whatever the industry, that there will be needs, most likely, but certainly an interest, to use more widely AI solutions, as reflected here, for instance, by the development and the launch of this ChatGPT Enterprise solution by OpenAI, whereby this shows perhaps a trend which will increase in the future. And also, obviously, this is quite recent development, the fact that obviously this is an important risk that should be managed by company, even obviously beyond the copyright risk. Now, what can be done in terms of risk management? One thing which comes to mind is to look at what could be included when companies externalize certain creative activities. You have an example on the screen in the advertising industry, where basically, as you can see, and this is a document coming from the US, there is an obligation of the advertising agency, as you can read at the bottom of the screen, a new provision which was included in that version 3.0 of the document, the template agreement that we have here, to disclose whether they've used artificial intelligence. And unsurprisingly, as you will have seen, this goes back here again to the very concept of obligation of transparency here from a contractual perspective. And one thing that perhaps is not optimally regulated in that document, I may criticize it, is that obviously if you have, and going back to the discussion that we had earlier, if we have a content which has been generated purely by AI, so generated AI content, that means obviously that there shall be no copyright on that content. So in that case, and this is the provision that you have on the screen, there shall be no validity or no use of a clause by which the agency would somehow transfer whatever the tool might be relevant. And this is a reference to the Works Made for Hire doctrine, which is a US copyright doctrine, but this is not really relevant for discussion here. But the point is to realize that if you have a purely AI generated content as of today, there shall be no copyright on that content, and consequently, there shall be no valid assignment of any copyright because there is no copyright on that content. So that's one line of like paying attention to contractual drafting. And of course, connected to that, obviously, and this is obviously a much bigger topic, is to see to what extent insurances may come into play and may cover this type of AI-related IP risk. And reference here to a recent report which was published by this leading US firm, which talks about, as you can read, some insurance implications of AI, showing that this type of course, way to managing risk will have a critical importance, specifically also for IP. This is what you have at the bottom right of the screen. That's just 2 words on micro perspective. What about macro perspective? And I think, and I'll terminate on that basically, we, I think, have to be aware that these perhaps very detailed and sophisticated and perhaps complex discussion as to whether AI might infringe IP protection, might be protected by copyright or not, should be put, of course, in a much broader perspective. We're dealing, of course, with an environment where AI, as we all know, will play a growing role for economies, for countries. And we just have to make sure that whatever the regulation that shall be adopted, it shall not be detrimental to the development of local industry. And thinking again about Japan, they wanted an AI-friendly environment to make data processing easier. Is that sufficient? Of course, it's one of the tools, but you see that reflected in this very interesting paper of the celebrated and well-known thinker and author Yuval Noah Harari, whom I'm sure you know well. And obviously, and I'll terminate on that, and that's going to be the final slide. I'm not claiming, obviously, that any of what I've just mentioned will make it possible to prepare for and predict the future. You see that reflected in this very recent paper, which was just published in the leading Harvard Business Review, which shows that obviously we have to look very carefully at what's happening and try to see, without predicting, of course, to try and prepare as much for a future where AI will obviously play a growing role. Thank you very much for your attention.